Um, so I'll just introduce Professor Lee while he is finding his slides. Professor Lee comes from the Tsinghua University in Beijing. He actually started his life with a Bachelor of Engineering, but then moved on to a Master of Law. And so and I should say his research spans intellectual property and cyberspace law. So if you're ready, I'll hand it over to you.
Okay, thank you. First of all, I would like to express my great gratitude to Professor Dan Di and Professor Mark Janis for your invitation. And I enjoyed this conference quite a lot. And I'm from China, and basically I will tell you something happening in China about the overlap IP protection of design. The reason why I chose this topic, there are two reasons that I chose this topic. The first reason is that actually the design patent plays a much more important role in China nowadays. The statistics shows that from the year 2000 to 2010, the application number of Chinese design patents increased dramatically from 46,000 to 421,000. So nowadays, the enterprises pays much more attention to their protection of design. Another reason is that from 2001, from August of 2001, I'm leading a research group on the research work of the design patent protection for goods in China. But as you might know, that yesterday, the director from the Huawei company has said that actually in China there is no such protection for goods in its patent law. Actually, it's excluded from the patent protection in China for goods. So such kind of, maybe the icons and the graphic user interface appeared in these equipments cannot be protected by patent law in China. The interpretation of Chinese government actually is showed in the guidance for the examination. It said basically it says that because it is not the physical patent, but only shows after it was electrified, so it is not the inherent pattern of the design. So we cannot protect such kind of subject because it's not fit for the definition of the design in Chinese patent law. And the comparative study shows that the United States, the EU, the Japan, South Korea, and even Taiwan also protect the goods in its patent law or design law. But our research work shows that even in the condition that China didn't provide design patent protection to goods, it actually the owner or the holder of the goods can also seek the protection from other IP laws, such as the copyright law. Actually, this is a case happening in South China, in Guangdong province. The owner want to protect its email system, the goods of its email system, and also can seek protection from trademark law. This is a case happening in Hebei province in Shijiazhuang. The product there is a personal digital assistant equipment, and also you can seek the protection from the unfair competition law. This is a case happening in Beijing that actually the defendant copied the website and just run a subway system, a subway administrative system. So my question actually is that since the owner or the holder of the goods actually can seek the protection from other IP rights, so is that means that the design patent is somehow redundant, maybe? Or so if we think that the holder actually can seek the protection from many other IP rights, so why you should choose design law? And so are there any overlapping of this kind of IP rights? And if there are many overlapping of this kind of rights, are there any conflicts between them? And once there are some conflicts, how does the court solve this problem? And actually, we collected some cases and to show that actually it happened that in China there are overlapping protections of the copyright and design patent law. The following cases are the cases that related to the overlapping protection of copyright law and the design law. The first case related to the product, such kind of, well, why these pictures cannot be shown? Oh, okay. Related to this kind of product, actually it's a basket rack for baths. Yeah, when you take a shower, you can put the clothes or towels into this kind of basket, and also these are the products involved in this case. Actually, the owner of this product actually applied the design patent for this product too, but he just seek for the copyright protection from the court. And in the first level, the court seems agree that this can be protected by copyright, and this is a kind of applied art. But in the appeal court, it was reversed. So also, what happened in this case is a kind of seal with a diamond head, and the court believed that it is a kind of applied art, so it can be protected by the copyright. And also this product also applied for the design patent, and actually it get the authorization. So in these two cases, actually the owner of the product, although he has applied for the design patent, he didn't use the patent to protect this to prevent the copy, but other is used the copyright, because I guess the copyright is much more broad than the design patent. And in this case, actually, it's an Italian company sued the Chinese company for the copy of the baby care equipment, such as the toilet seat and the toilet seat pad, and this is a kind of a shower chair. So in this case, the court just said that it can be protected because it's a kind of applied art. So in China, when you think all these cases, you cannot know the standard, how to judge the product is a kind of applied art. And there is no such kind of doctrine or standard for the protection to how to draw a line between the design patent law and copyright law. So I here mentioned the case happening in United States, which actually established the doctrine of separability. But just like the little Goldman in the Rolls-Royce car. But in China, we didn't have such a doctrine, and there's some kind of uncertainty about whether this is a kind of applied art or not. So this may cause some confusing in the case. Well, I will mention the confliction afterwards, but here I will just talk about the overlapping protection of the trademark and design law. But in China, the overlapping protection of trademark law and design law is somehow difficult. The reason behind is that in 2008, actually, China passed the new patent law, which state clearly that the two-dimensional artistic works or plenary printed works cannot be protected by the design law, and if it can be, it has a distinctive character, it cannot be protected by design law too. So either so. Actually, just limited the protection of overlapping protection on those two-dimensional artistic works from 2008. So this is a case that actually shows the Coca-Cola company applied the three-dimensional trademark in the trademark office, and actually it's denied because the the government official says that there is no distinctivity of this button, of this shape of button. And another case related to Amazon company, and he thinks that he has broadly used these bolts in the mechanic equipment, so it can be protected as a three-dimensional trademark. But what happened in China is that the government officials, the PTO, the court, they said that there is no distinctivity of this product, so it cannot be protected by trademark. So basically, in China, I guess it's very difficult to get the protection of trademark law for the for the product, especially if you want to get the three-dimensional trademark. So compare with the EU case in this about the protection of the razor, the Philip razor. Actually, I guess the functionality also plays an important role in the deny of the protection of trademark law in China. So also we seek we did some research work on the United States, and we found that actually Apple has applied such kind of design trademark for its iPod series products, and also it applied the design trademark protection for its iPad tables. So in China, the situation is somehow like that. The applied art and the design patent protection is quite possible, but compared with the overlapping protection of copyright and the design protection, it's much difficult for the overlapping protection of design patent and the trade dress. I just mentioned that actually in 2008, the new patent law excluded such kind of two-dimensional and primary printed works out of the design protection. Somehow, I guess it's because that it just brings some troubles to the judicial court, and I will tell you two cases that actually it's just mentioned this kind of subject, and the court found it very difficult to decide how to protect such kind of subject. This is a case that happened in Shenzhen, South China. And the subject here actually is very simple. This is a lawsuit between two food companies. They all produce the oil. And the plaintiff actually applied the design patent for its oil bag, for the package of its oil bag. And the question here is that he didn't pay the maintenance fee for its design patent. So after about 3 years, it was invalidated. But in this case, actually the plaintiff sued the defendant for the copyright infringement, because the defendant just used the same package in its oil bag, and the court found it difficult to decide whether it can be protected by the copyright or not. One kind of opinion is that since this kind of design patent is invalidated, and then the design went into the public domain, and everyone can use it freely, especially when it's used in the oil bag. But another kind of opinion says that since the overlapping protection means that actually there are two kinds of rights over this kind of bag. So the cease of the design patent doesn't mean that the copyright also ceased. So finally, the court said that we didn't provide the copyright protection to such kind of oil bag if the design patent has already ceased. So, but you know, from this is just a one case to show that there are controversial issues in this kind of overlapping protection. And another case shows the controversial issue about the overlapping protection of the trademark law and the design law. In this case, it's very simple. The subject is just a kind of the package of noodles. So also the plaintiff also applied the design patent for these drawings, maybe these pictures. But he applied the design patent, and since in China we didn't have the substantive examination, so it get the authorization. And the tricky point of this case is that the trademark owner actually used the same subject, applied the trademark before the design application, but he get the authorization after the design application and before the design was authorized. So the trademark owner says that the design should be abolished because he has a trademark right on that kind of package. But the design owner says that you should say the law to say whether the right of the design right can be abolished, because in China we say that if there is a prior right in this kind of trademark or in this kind of design right, then it can be abolished and it can be invalidated. So the problem here is that when the design is applying, the trademark right has not been established. So actually it cannot be invalidated. So this is a case that happened in 2010, and actually it's still pending because even the judges in the Beijing High Court find it's very confusing, and he didn't know the appropriate solution for this case is. So maybe from after 2008, after the new patent law, such kind of cases were decreased dramatically. But I guess still there are some cases related to the protection of three-dimensional products. Not only that, as these two cases shows, it's only related to the two-dimensional artistic pictures. So my suggestion is that maybe in China we should just limit the situation of overlapping of protection of trademark law and the design patent law, but we could provide the overlapping protection for the copyright and the design law, especially to those applied artwork. So, but I guess maybe you have much more suggestions and advices for China's legislation. Thank you.